has been practicing as an arguing counsel for the last 34 years and appearing in the Supreme Court of India as well as various high courts across India besides practicing in Bombay High Court. He has taught law, LLM in University of Mumbai, LLB in Government Law College Churchgate, Mumbai, and has regularly invited by various other law colleges. He also writes legal articles and columns in magazines and websites. His articles and speeches are widely hailed. His law book on media laws has been recently released and is widely hailed. Shri Puneet Chaturvedi sir has also been addressing the annual law training and lecture series conducted by Bar Council of Maharashtra and Goa on the Constitution of India. He provides free legal aid and argues several public interest litigations. He has been addressing and enlightened several professional forums, institutions, colleges, corporate houses, bar associations on various subjects of laws. Interestingly, his live talks also often attended by judiciary also. Besides the above, he has also been addressing different medical forums on medical legal topics. He is the process of authoring his next book on medical laws. Shri Puneet Chaturvedi sir has also been appearing as a law expert in the property show on NDTV and is invited by different television channels to speak on various legal topics. Interestingly, Shri Puneet Chaturvedi sir is also a noted scholar of the ancient Indian scriptures like Ved, Vedanta, Upanishads, Puran, Bhagavad Gita, Ramayana, etc. and has developed extremely lucid and pragmatic applications deriving from Ved Vedanta. His discourses on the logical interpretation of Ved Vedanta, Bhagavad Gita, Ramayana and other ancient scriptures are organized across India and abroad. He has conducted Vedantic workshops in schools, colleges, management institutions, corporate houses, chambers of commerce, jails, clubs, courts and many more. He also writes articles on Vedantic principles. His Vedantic talks can be seen on the YouTube channel Puneet Chaturvedi Ved Vedanta, whereas one can listen to his talks on various topics of law on his YouTube channel Puneet Chaturvedi Advocate. Shri Puneet Chaturvedi Advocate is also assisted by his wife Srimati Rashmi Chaturvedi. We welcome you here, sir, today. We are honored to host you.
The honorable judges, it's always develops a nerve center when you appear in a crucial matter before any bench. Think of my plight when I'm made to appear with this august gathering of all the honorable judges together. So it's quite difficult. I hope that I could be of some assistance on the 3 new laws being introduced in the Parliament of India and got assent to the President of India on 25th December 2023. As being told, we shall be beginning with Bhartiya Sakshya Adhiniyam, which as on today is Indian Evidence Act 1872. Now, Indian Evidence Act 1872 has served us for almost a century and a half. 146 years to be precise. Indian Evidence Act, as we all are aware, was classified into 3 parts, having 11 chapters and 167 sections. Now, contrary to that, Bhartiya Sanhita 2023 classifies the statute into 4 parts. having 12 chapters and 170 sections, 170. But what is most significant to notice here is that it also adds a schedule to it which was absent in the Indian Evidence Act. And much needed schedule, to let us all admit. There are some significant changes into Bhartiya Sanhita, or more or less retaining the principles of evidence primarily as it is. So the principles of evidence do not undergo many changes. What Bhartiya Sanhita does is, it simply makes Indian Evidence Act contemporary with the current development of the society, with the advent of digital and electronic mediums. Now we all are aware that these mediums were absent in 1872. Although Indian Evidence Act underwent 27 amendments in 146 years. Among those 27 amendments, the Parliament in its wisdom tried to bring these digital and electronic aspects incorporated into Indian Evidence Act, but long felt the need for complete overhauling. Because Information Technology Act of 2000 also has been there for last 24 years. And the digital aspects had been growing and rampant in the society. Therefore, if we notice, Bhartiya Sanhita predominantly includes electronic and digital aspect more, rather than changing those principles of evidence. Because the principles of evidence remain the same. So let us analyze part by part what changes happened from Indian Evidence Act to Bhartiya Sanhita. Part 1 of Bhartiya Sanhita, which is a newly added part, because if you see Indian Evidence Act, which was having 3 parts. Now the part 1, part 2 and part 3 of Indian Evidence Act became part 2, part 3 and part 4 of Bhartiya Sanhita. By adding one more part called preliminary, headed under the heading of preliminary. Now this preliminary part has only one chapter, named as chapter 1, having only 2 sections. Section 1 of Bhartiya Sanhita, if you compare it with section 1 of Indian Evidence Act, underwent some changes. The very significant modification under section 1 of Bhartiya Sanhita is that the word extent is missing. Normally, in every statute, we are quite habitual of reading the commencement and extent of the act. The word extent is missing from Bhartiya Nyaya Sanhita because we all are aware that the word extent has two features always. Wherever the word extent appears in any statute, extent has two features. It covers territorial extent and it also covers the subject matter of extent. For example, territorial extent means prior to abrogation of Article 370, most of the statutes used to put extent means excluding state of Jammu and Kashmir. It will be applicable to the whole of India excluding the state of Jammu and Kashmir. Now with the abrogation of Article 370 and subsequent statute being Bhartiya Nyaya Sanhita, it was felt that the extent of territorial aspect is not needed because there is no exclusion anymore of any territorial area of India. And therefore, if you notice, from section 3 of the Indian Evidence Act, the definition of India is also repeated, is removed. Now section 3 of Indian Evidence Act does not carry in Bhartiya Nyaya Sanhita the definition of India. Because the definition of India in 1872 must have been different. Today, India has taken a different shape altogether. We do not have princely states. We do not have foreign territories like French occupied areas, Portugal occupied areas, which was then prevalent, and British India was quite a limited territory. And therefore, from the extent of that definition under section 1, it's only the commencement and application of Bhartiya Nyaya Sanhita. The word extent is missing, which is quite noticeable. The second extent aspect is subject matter. Whenever we talk about extent of any statute, it has two connotations. One is territorial connotation, the other is subject matter connotation. So the subject matter connotation of the Indian Evidence Act is also underwent a sea change in Bhartiya Nyaya Sanhita. Now if you see Bhartiya Nyaya Sanhita, in subclause 2 of section 1, it states that its application is in all the civil as well as criminal proceedings before the court of law, including court-martials. Now, if you see section 1 of Indian Evidence Act, it had a long application which included Army Act, Navy Act, Air Force Act. All that has been repeated. It's been streamlined directly to one liner. That the extent of the application of Bhartiya Nyaya Sanhita would be to all the civil as well as criminal proceedings before the court of law, including court-martial, but it excludes only two aspects. That Bhartiya Nyaya Sanhita would not be applicable on affidavits and on arbitration. As far as arbitration is concerned, before I proceed further, sorry, I apologize. It must be Bhartiya Sakshya Adhiniyam. Nyaya Sanhita is IPC. Bhartiya Sakshya Adhiniyam 2023. So, it's an arbitration. Now, as far as arbitration aspect is concerned, it is very important to note here that like Indian Evidence Act, which also excluded arbitration, Bhartiya Nyaya Sanhita, though excludes arbitration, but there is no prohibition. That is very important to note. That if the arbitrator or arbitral tribunal, as well as the litigating parties before the arbitrator, if they all choose to apply the principles of evidence, then Bhartiya Sakshya Adhiniyam would apply on arbitration also. So it has been voluntary. There is no prohibition, but as such, Bhartiya Sakshya Adhiniyam is not applicable on arbitration as well as on affidavits. Now, before I move further, let us stick to section 1 first to understand that what I noticed while researching on Bhartiya Sakshya Adhiniyam, a very interesting feature which I would like to share with you, which I'm sure when you will go through all that extensively, you will also notice that though the name has been changed from Indian Evidence Act to Bhartiya Sakshya Adhiniyam, the entire statute of 2023 nowhere defines Sakshya. It is very interesting, and I'm sure that in future with the amendments, the Parliament will wake up and bring some definition to what do they mean by Sakshya, because in Sakshya Adhiniyam also they continue to define evidence, what was defined in Evidence Act of 1872, and probably it is left for us to presume that evidence is Sakshya. So it's just a kind of happy presumption that we all have to kind of believe in. Otherwise, if Indian Evidence Act, according to me, defines evidence, Bhartiya Sakshya Adhiniyam must have also defined Sakshya. Or maybe to keep the word Sakshya replacing evidence, if they meant the same. But that's missing. So I'm pretty amazed that one day when I will be appearing in operation of Bhartiya Sakshya Adhiniyam, we will have to fall back upon the dictionary to understand what is Sakshya and to interpret before the Honorable Courts. That's by Sakshya we meant this, because while reading and while noticing this absence, a remarkable absence, I had to fall back upon a dictionary to find out what are the connotations of Sakshya other than the general understanding. And what is very interesting that I came to know, the word Sakshya emerged from the word being Sakshi. Sakshi means someone in Sanskrit. If we bifurcate this word, it becomes Sa Aksha. Aksha means eyes, and someone who with his eyes is noticing something becomes Sa-Aksha. So Saksha is, according to dictionary meaning, is something which is seen. Whereas Indian Evidence Act puts evidence, if we see the definition of evidence, it has three connotations: seeing, hearing, and perceiving. Three aspects of evidence. And we all know that when we have been habitual of this definition of evidence from Indian Evidence Act, that the primary witness is the one who has seen it, or the one who has heard it himself, or the one who has perceived it from his own senses. So when the dictionary meaning giving a different connotation to sakshya, limiting it to seeing, it was, according to me, in my humble opinion, and whatever little understanding I have, that it was important for the Parliament to define sakshya with giving a larger meaning of covering all the three aspects, so that we need not to fall back upon the dictionaries to interpret sakshya. Now, moving ahead, Section 2 has been introduced, replacing Section 3 and 4 of Indian Evidence Act. Section 3 and 4 of the Indian Evidence Act gave most of the definitions, like document, evidence, proved, not proved, disproved. All that is between 3 and 4, and unfortunately not numbered. Now, Bhartiya Sakshya Adhiniyam, though retains most of these definitions, but brought it under the umbrella of Section 2 and has chronicled it into alphabetical order. So now what we had in Section 3 and 4 of the Indian Evidence Act, all that has been brought under the single umbrella of Section 2, A, B, C, D, E, F, G. And now you would be noticing it under Bhartiya Sakshya Sanhita that it is chronicled under alphabetical order. So you may get first the definition of may proved, then alphabetically you will get the definition of not proved, because MN, and then you will get the definition of proved, P. So though they tried, the Parliament in its wisdom tried to bring it some kind of chronicle sequence into it, but if you read, it looks little absurd, because we all habituated to have been clubbing things that proved, not may prove, not proved. Kind of thing is clubbed. Here this clubbing is disturbed, and now it's as per alphabet things have been put. And as I said, from the definitions of two changes have been made. One, India is missing, and one word is added, words and phrases, which has been added in the definition clause. And what does it say, words and phrases? It just simply says that words and phrases of any other law, including Information Technology Act of 2000, the words and phrases used in Bharatiya Nyaya Sanhita and the words and phrases used in Bharatiya Nagarik Suraksha Sanhita would have the same application under Bhartiya Sakshya Adhiniyam. So this is new addition which was missing in Indian Evidence Act. And from the definition clause, what was there as India is now removed. So 3 and 4 conglomerated under Section 2. And that completes your part 1 of Bhartiya Sakshya Adhiniyam, comprising of only 2 sections, only 1 chapter. Now we come to what was part 1 of Indian Evidence Act, became part 2 of Bhartiya Sakshya Adhiniyam, that is relevancy of facts. The chapter titled as Relevancy in Indian Evidence Act has been retained here in Bhartiya Sakshya Adhiniyam as relevance. Now part 2 now begins from section 3 and runs up to section 50. So as good as 48 sections into relevance. There are two major changes into this part 2. Because part 2 also have only one chapter. Like part 1 has one chapter, chapter 1. Part 2 also has only one chapter, chapter 2. Chapter 2 has 48 sections, chapter 1 has only 2 sections. Now chapter 2, which talks about relevance, deletes section 22A of Indian Evidence Act. Now that's no more there in Bhartiya Sakshya Adhiniyam. 22A have been removed. And what was 25, 26 and 27 of Indian Evidence Act, the provisions related to confession. Now 25, 26 and 27 have been consolidated under section 23. So those separate provisions are now consolidated into one. And 25, 26, 27 became section 23. So that scattered confession brought under one umbrella and subclauses. Whereas if you notice, inside these subclauses, which were earlier 25, 26, 27, the content remains more or less the same. Only the sequence of the sections have been changed to kind of make it more systematic and chronologically understandable. Apart from these two changes, there's not much, because principles of relevance remains the same, whether it's res gestae or whether it is kind of things done, felt, or whatever. All those principles retained as it is. Not much change has happened. Only thing is that some cosmetic titling have been changed, some cosmetic sequencing have been changed, but rest all relevance remains the same, because actually we all are in the field of law for ages now. We all are habitual to understand that you can't go beyond those principles of relevance. They remain, they are very scientific, they are so, what change can you do as far as relevance is concerned? Whenever you are litigating in the court of law, even if the lawyers like us go haywire, the judges bring them to the point in issue, the fact in issue, the relevant fact. You can't just go haywire. So the relevance always remains predominant. And if the litigating lawyers transgress relevance, the honorable judges always bring them back to the track. They remain relevant to the issue. Don't go here and there. So if we see, you actually can't tinker with those principles of relevance. You can't do it. So that's what, thankfully, the Parliament has also not tinkered with those principles. Only thing is that the section numbers have changed, which will make all of us to remember it right from inception now. It is what was ingrained in our brain for last so many years. The numbers have changed. So what was 25 has become 23, and what was 5, 6, 7 has become 2, 3, 5. So that's how these number games have changed, and we will have to undergo that. So part 2
apart from these two changes, removing section 22A and bringing confession into consolidation, rest all in principle remains the same, though here and though their numbering must have changed. And that brings to part 3. What was part 2 in the Indian Evidence Act became part 3 of Bhartiya Sakshya Adhiniyam, has undergone major changes. So it is part 3, the burden of proof, which is the area which has undergone major changes. Because as far as part 4 is concerned, before I come to part 3, let us do and dust part 4 also, because it has only one change, that section 2 of Indian Evidence Act has been brought down to as section 170 into part 4. That is a repealing provision which repeals Indian Evidence Act. So what was section 2 in Indian Evidence Act became section 170 of Bhartiya Sakshya Adhiniyam. Because when Indian Evidence Act had come in 1872, they had nothing to repeal. So that was the first introduced Indian Evidence Act. There was nothing prior to that to repeal. So it was worded in a different fashion. If you see section 2 of Indian Evidence Act, it was worded in a different fashion. And 170 actually is repealing and savings provision. And we all are aware that once whatever is repealed, it's always clubbed with savings, because you save that all the litigations which have been pending under the erstwhile act continues till everything is over in respect of that statute. So that repeal and savings is 170 now in Bhartiya Sakshya Adhiniyam. So that brings us to part 3, which underwent major changes. And part 3 has 4 chapters, though part 4 has 5 chapters, bringing 2 to 170. And I'll touch those 5 chapters, because those 5 chapters have also not gone much changes, but except the sequencing have been changed, the section numbers have been changed. And few, I'll just touch and go what slight changes in part 4 also happened, because that has 5 kind of chapters, which includes estoppel and all that, and the exclusion of evidences, oral and written. But important is part 3. Now part 3, which in the Indian Evidence Act, part 2 began from section 59. Here it begins from section 51, because part 1 has 2 to 50. So it becomes 51 onwards here. And what was 57 of Indian Evidence Act became 52 of Bhartiya Sakshya Adhiniyam. Now 52 adds 5 subclauses: A, B, C, D, E. 52, just to kind of remind you what was Indian Evidence Act 57 was, things which are need not to be proved because they are taken judicial notice of. So there was a list of the facts which were taken judicial notice of and need not to be proved. That list was already there under Indian Evidence Act. That list of 57 is brought under section 52 of Bhartiya Sakshya Adhiniyam, with adding 5 more clauses, A, B, C, D, E, which now would be taken judicial notice of and need not to be proved. And what was 57 brought as 52 of Sakshya Adhiniyam, removes certain things, which was in 57. Now, I need not to tell this august gathering, who is so much aware into Indian Evidence Act. But one thing which all of us must be wondering till now, over the years of our practice or being at the bar or at the bench, that why Indian Evidence Act 70 years down the line after independence carries on the words like Queen, King, Crown, Parliament of United Kingdom, Parliament of England. All those words are now removed. And that removes some changes in each of the clause of earlier section 57 now became 52. Wherever under 57 there were the words King, Queen, Crown, England, UK, Parliament of England, Commonwealth, wherever those words were there which were archaic and not needed anymore, are all removed. So now Bhartiya Sakshya Adhiniyam is more streamlined, and the judges and the courts are not under obligation anymore to take judicial notice of the laws passed in the Parliament of India. Because till June 30th, we still have an opportunity to compel our judges to take judicial notice of the statute passed in the Parliament of India, because that carries on till date. So from 1st July onwards, nobody can compel the bench to take judicial notice of. We will have to prove that this statute is there. So all those foreign words and archaic words which reminded us of our slavery days are now over. So that's removed. And they were there in so many clauses of section 57. In 52, though we added 5 more clauses, we removed all those archaic words. So 5 more clauses are like the treaties and the agreements done by India are now taken judicial notice of. So whatever international treaties Government of India enters into, one has to simply produce the treaty before the court, and it need not to be proved. The courts will take judicial notice of it. Similarly, the orders passed by tribunals are also included now, because earlier it was only court of law. Because in fact, actually in 1872 there were no tribunals. Now the orders passed by tribunals are also taken judicial notice of. You just produce the copy of the order of the tribunal, and you need not to prove that before the court of law. And that's how subclause A, B, C, D, E are added into section 52. Now, the most important significant change that happened in the Bhartiya Sakshya Adhiniyam, and which has in fact troubled all of us for a pretty long time. Now, till it was limited to 2 kinds of evidence, we all were comfortable. Because section 61 and 62 of Indian Evidence Act used to define primary and secondary evidence. So we all were comfortable. We were quite habitual of with what is primary evidence and what is secondary evidence. Practiced ages. The trouble began with the advent of digital era. And it was, we all were flummoxed, and quite zapped when digital evidences used to come. And therefore quite late after Information Technology Act of 2000, the Indian Evidence Act was amended with section 65A and 65B. Now, though it was amended, how to prove an electronic evidence, it still flummoxed everybody. It was so cumbersome, it was so haphazardly drafted, to confess before honorable judges, that it took me several rounds of reading to understand what is 65B, because when you begin from 65B beginning, by the end you came down, you forgot what was in the earlier. So you have to make round and round to understand what is 65B and how to prove that. And incidentally, 65B stated that whenever you produce a secondary evidence of electronic document, it has to be along with a certificate of section 65B. And how to draft that certificate? The statute was silent. So it was left to each and one's wisdom what to write under that certificate and to who to certify. Nothing was clarified. 65B certificates were flaunted across the court in different formats, and everybody said, we are the ones who are right. And the honorable benches were also flummoxed who to consider right and who to consider wrong, because there was no standard. So whoever wanted whatever was doing it. And it had become actually a formality. Whatever you just take out a printout of WhatsApp, or you take a printout of email, or whatever is electronic evidence or photograph, and you just slap it with one covering letter of 65E and produce it. And rest you leave to the court. And the courts were also clueless, so they said, 65B laga hai? Haan laga hai sir. Bas theek. Unmindful of the fact and which I really wonder most of the lawyers in the bar are clueless about the fact that there are 3 steps of Evidence Act. First is producing. Production does not make anything anywhere. You simply produce a document. The second step is exhibiting of a document. Now, exhibiting of a document, with quite responsibility at my command, I must confess that 90% of the bar is under the impression that once the document is exhibited, that means we are through. Which is not the truth. Exhibiting of a document is a ministerial act, an administrative act, simply to giving a number to a document, to identify the document. The third step is the most important step of a production of a document: production, exhibiting, and then proving of the document, which most of the members of the bar forget. They keep on harping upon the honorable benches, which you all must be experiencing day in, day out. The lawyers must be harping, sir, exhibit to hai. And the judges say, हाँ भाई exhibit है मगर proof तो करो. अरे अब क्या proof करें? Exhibit तो हो गया. Without understanding, exhibiting is a ministerial act. There is no application of judicial mind to apply to exhibit a document or not to exhibit. Sometimes judges exhibit the document, but only they test on 2 parameters: whether it falls under primary evidence or not, and if not, whether it falls under secondary evidence or not. That's it. If either of the criteria is fulfilled, the document is exhibited. Now, the burden is on the lawyer to prove that document. As far as electronic documents are concerned, everybody was so clueless The moment with 65B covering letter, you produce an electronic document with a printout, and the Honorable Judge has exhibited it, rest all is forgotten. People used to consider that it is proved. This is far from the truth. After exhibiting comes the actual test. You have to prove that document. Now, all that has taken care of in Bhartiya Sakshya Adhiniyam. So that section 65, which defined that what cannot be proved through primary evidence has to be proved through secondary evidence. Then as far as electronic evidence as a secondary evidence was concerned, 65A was introduced after IT Act of 2000. That which 65A stated that all the electronic evidence will be considered as secondary evidence. And 65B stated that how to prove the electronic evidence. Those steps were there. Now for relief to all of us, whether it is bar or for the bench, all that had been consolidated under one section, section 63. So now section 63 covers 65A, 65B, everything is under section 63. Now 63, sorry, I'm so thankful. 63, this also happens in actual courts of law, just for the lighter note, that whenever you are in the flow of arguing something, the bench interjects you. All right, don't do that. Give me this, and you lose that flow of the arguments. Anyway, so 63 brings the entire 65A, 65B proving of a document under 63. Not only that 63 is the best change brought in by Bhartiya Sakshya Adhiniyam, what is more important, that 63, subclause 3, subclause C attaches a format of certificate. That's the best thing of this Bhartiya Sakshya Adhiniyam. And that is where I said that Bhartiya Sakshya Adhiniyam adds one schedule which was not there in Indian Evidence Act. Schedule 1 of Bhartiya Sakshya Adhiniyam gives you the format of the 65B certificate. Now it is 63 4C. 63 subclause 4 subclause C. So that certificate is now in format, and that certificate is now divided into two parts. If you observe Schedule 1 of Bhartiya Sakshya Adhiniyam, Schedule 1 gives format, and that form is divided into two parts. Part A is a declaration by the owner of the gadget from which this printout is taken or the electronic evidence has been transacted with, whether he is the owner of the computer from which the printout is taken. And one more thing, one significant change before I forget. Earlier it was computer only. Now Bhartiya Sakshya Adhiniyam, in addition to that, includes communication devices also. So that includes mobile and iPads and all that. So earlier it was only computer, now communication devices includes WhatsApp, emails, everything. So photograph, audios, videos, everything. So communication devices. Now, whoever is the owner of computer and communication devices has to certify the first part of that certificate. And second part, part B, in that form, Schedule 1, is to be certified by an expert. So now, what we used to commonly produce 65B certificate by the owner of the computer or gadget, taking the responsibility on its own that it is used by me, it is purchased by me, and I have taken the printout and no changes has happened and all that. Now, it is limited only to Part A, and it has to be included with Part B, because Part B says that same thing has to be declared and certified by an expert. Before I move forward, where you have a sigh of relief that now there is a format of 65B, there is some lacuna still left. In my humble opinion, with my reading, whatever I could gather, that lacuna left is that it still does not define who's the expert who would execute that Part B certificate. So I'm sure with coming amendments, the Parliament would realize these lacunas and add those definitions of who's the expert, because you have to identify. Now, one more thing which is lacuna according to me, and which we learn from practicing. If we go by theoretical reading, we may not realize, but by practicing law, you realize that these lacunas are there because you face them in the courts of law day in, day out. One more lacuna in Part A is also felt by me, that though it does not define expert in Part B, first Part A, one has to define who do you mean by the owner? Whether it is the author of the communication or it is the recipient of the communication. Who will certify? At the moment it is left with the owner of the gadget from which the printout is taken. So whether he is the author or he is the recipient, or one must wonder, and that is where the catch is, that simply by exhibiting nothing happens, because the Parliament has forgotten to consider, unlike the document defined under Evidence Act, which used to be the document on any substance like paper, metal, or stone carvings and all that. Here we are dealing with digital document, which is prone to be tinkered with. You can't tinker with a carving on a stone. You can't tinker with something which is embossed on a metal. You can't tinker it with something, a document printed, because any changes, modifications can be noticed. But as far as digital document is concerned, it can be easily tinkered with. One can delete something, one can modify something. And that has to be taken care of. And that is where it is very important that even if the digital document is exhibited, the burden of proving remains, that it is not altered. Because you are aware that, forget about the digital transactions and electronic communications, the era has come of AI, artificial intelligence, which is modifying even the persona, the audio, the video. Today I am talking before this August gathering of honorable judges about the Bhartiya Sakshya Adhiniyam. And this audio and video very easily can be altered as if I am singing a song. This audience who's listening to me in rapt attention with Bhartiya Sakshya Adhiniyam can be altered to have been having a laughter. All this is possible in the era of artificial intelligence, so one has to be very careful. And that is where I felt, in my humble opinion, that this is lacking. So I tried to give you the critical aspects also of whatever changes happened in Bhartiya Sakshya Adhiniyam. Then there are certain changes, cosmetic changes in Section 81, 81A of the Indian Evidence Act, and 126 has been changed to 132.5. बेटा ये हो गया 10 मिनट? अच्छा, okay. 2 मिनट और खत्म ही कर. So 126 has become 137 sub clause 2, 141, 142, 143 has become 146, 81, 81A has been clubbed together, and from 88, 89, 90, wherever there were the words England and UK and all has been deleted. Now this chit further says that I am obliged to have an interactive section of question and answers. So I'm ready. Yes, please.
Section 1 excludes affidavit.
That's true.
So what will be the effect of the affidavits under Order 18 of secrecy?
Sir, with due respect, this is not even the change in Bhartiya Sakshya. It was there in the Evidence Act. So affidavits were always out of the purview. As far as now you very kind of analyzing thought which you had given, what would happen to 18 CPC? Because now we are providing all the examination in chief through affidavit only, instead of bringing the into a witness box and making him swear before the court and do this. The fact is, with due and respect and humble opinion, that affidavit is only produced. It is not that simply you produce the affidavit, but then you have to undergo cross-examination. Only then that affidavit is necessary to be proved. So therefore, though that change had happened in CPC, and now also not only in CPC, though it is not applicable in CRPC altogether, but certain criminal provisions like 138 Negotiable Instruments Act, etc., brings the examination chief through affidavit. And some of the petty offences also are covered even in CRPC to be produced with the affidavit of examination chief. And then suddenly, now plus one more thing which reminds me that most of the complaint cases which does not come through FIR are also through affidavits. But then those affidavits are also not evidence. They are yet to be proved. And therefore, that is in sync with Indian Evidence Act, that the affidavit is excluded. It was excluded in Indian Evidence Act also under Section 1. It is excluded here also. I hope that answers your questions. Any further subsequent question to that? I'm obliged. Thank you. Areva. Thank you. This is the segment which I have more time. You can grill me. You can grill me because where I was trying to cover up more and more, I was told that I don't have much time. But this is the segment which still have a lot of window. You can ask any question and grill me. Like you all are habitual of grilling us in the bench, sitting in the bench to be lawyers. In the absence of question on a lighter note, what I gather is, whenever I do not get questions from audience, there are only two deductions. Either I was too good or I was too bad. Nobody considers me to have asked any questions. Yes.
These acts will have prospective effect. That means all cases as on pending, as on date, will be tried and governed by the old act.
That's
It
true.
will continue till those all matters are disposed of, whatever.
That's absolutely true. And that's
It
what,
will be applicable only if some new crime takes place. or
from
new-
1st July onwards.
Yeah, a person has to file a new case. Only then it will be applicable.
1st July onwards. Like, shh. I just pray my lords not to behave like schoolboys at school. Pay attention to our honorable judges asking intelligent questions. Yes.
Because it is prospective effect, and if a case is filed on 29th of June, hypothetical situation I'm hearing, it will be governed under the old
Indian Evidence Act.
But while trying the matter, we we just don't remember that it is filed only 2 days before or 2 days after. So whether it will create any confusing or complicated situation?
I don't think so, because most of the things which are initiated has a cut-off date. No, even if the bench doesn't remember, the lawyers will remind you. If the finish this, what lawyers, if suppose the complainant lawyers or the claimant's lawyer will not remind you, the opposition will definitely remind the bench. So that's because there are always two sides and both sides undercut each other. So if one is trying to take advantage of a situation, the other one will definitely remind the bench that it is after 1st July. So it cannot undergo that trial under Indian Evidence Act. And
This will arise when a certificate under section
65, now it is 63(4)(c). 63(4) subclause C, read with Schedule 1. So that certificate will have to be only after 1st of July 2000. All the proceedings initiated after 1st July 2024. And if it is the proceedings continuation up to 30th June, we will have to, the bar and the bench all have to be under the burden of those haphazard certificates.
मैं क्या बोल रहा हूँ तेरे पास चेक कर मेरा एक कार्ड रहेगा 64 GB का 3 नंबर
That is 1st July onwards.
मेरा
Prior to 1st July, there is no. No, that is the area which I said that the expert has to be, I think, somebody, computer engineer or digital engineer, or maybe the one who's into the practice of computers knows. Because, excuse me, just a minute. It's a very, very intelligent discussion happening here, which may be useful to all of us.
उसके पहले तुम्हारा ऑर्डर किया था तभी तो मोबाइल किया
What Mr. Thackeray has just pointed out is that tomorrow, after 1st July, when this 63(4)(c) certificate given under Schedule 1 is produced before the court will still be under delusion who's the expert, because expert is not defined. And therefore, I just want to elaborate out of my humble opinion and experience that it has to be some computer engineer or somebody from the practice of computer who's been like computer mechanic, or who's been dealing with computer repair work and all, and software expert. But one thing which all of us must be aware of, that whoever that expert who gives that certificate is under the burden of being cross-examined. So if he's not the expert, whatever is expected by the wisdom of the parliament, he will be grilled, and the courts will come to know whether he's actually an expert or not. Because 65B, as I said, when we used to produce earlier also, is not considered to be proven. It's simply a covering letter to exhibit it. Same thing with 63(4)(c) certificate under Schedule 1. If it is signed and executed by an expert, that expert has to be cross-examined. So I think that answer your Honor's question. Yes.
Yes. We are still fortunate because from July onwards we have to deal with 2 sets of criminal laws, but in Jammu and Kashmir they have to deal with 3 sets of criminal laws.
That's right. That's
So,
right.
I am adding my question to this 65B certificate only. In the schedule, 2 parts are given for that certificate. First part
By the
has
owner.
to be filled by a party, and the second part has to be filled in by the
Expert.
But whether party and an expert can be the same person. So if I can explain by an example. If I take photographs of some house or building, and I take the printouts of that photographs from my mobile and from my printer only. So whether I can give as a party the part A certificate and as an expert of part B certificate. So whether it can be a same person for giving this.
Wonderful.
Who will be
Fantastic.
called in this case? Who will be called an expert? If I I have taken the printouts of those photographs on my
I got
printer.
it. I got it.
It's very, very intelligent query and very important for us. Because this question is the one which was troubling me since I read that Schedule 1 format. Now, with due respect to Madam who has raised this query, these aspects are left open to interpretation. And the future unfolds the answers which you question. Because I'm sure there would be innovative lawyers who would execute both sections or who would ask their clients to execute both. You are the expert. And I will prove it in the court.
Sir, he is a photographer, he is an expert, so if there is some dispute in
respect of his own,
he is a party as a person, so he can execute the certificate
As an owner as well as an expert.
expert also.
That's right. That's what I agreed with ma'am, that she's pretty right in saying that what if somebody signs both the parts?
There is no bar.
There's no bar. And there's no bar in the format, either in the section. It simply says that it has to be executed statistic. It simply says it has to be first part by the owner of the gadget and the second part by the expert, and without defining who's the expert. And that's where I totally agree with ma'am. That what if same person signs both? So it's open to, and absolutely supplemented by Your Honor, that if this cameraman has a personal litigation, he is the photographer and he produces a photograph, his lawyer will definitely say, you are the expert. Both certificate, both sides of certificate.
Sir, in my opinion, humble opinion,
Yes.
in our small bus code, there are a panelist by which we can look by Court Commissioner architecture or any BTech civil engineers. They can inspect the premises or valuers are there specially appointed. In my humble opinion that these certificate increases the scope of the civil engineers, computer engineers. Because if the madam says that I take the photographs from my mobile and I can give, then it is not proper in the eye of the law. So each and every court should appoint a list of the computer engineers, whether it is a diploma computer engineers or any experts or degree holders. Otherwise, these two certificates given by the same person, then it will be no use. So that computer engineer will come before the courts. That is the better idea.
That's precisely what Your Honor had just said. That's precisely my point. The things will unfold gradually and will answer these questions, because Your Honor is right that if we can appoint court commissioners in other areas, like the Honorable High Court of Bombay has a panel of arbitrators. One can always have a panel of experts. Each court can deduce some panel of experts that you have to get this certificate certified by the panel of the court. Wonderful idea, but what I kind of fall short of understanding, that though the process, when I underwent the process of this making of Bhartiya Sakshya Adhiniyam, I read that the government of India underwent a huge scrutiny, section by section, and invited opinions of experts. I am pretty sure that had they had obtained the services of this august gathering from this hall, they would have got better services, better opinions, and would have done a better job of bringing Bhartiya Sakshya Adhiniyam. I don't know which experts they
I'm sorry to disturb you, but if I can add, the party certificate which is by the party, that can that certificate and this other one, it is only having a difference of one paragraph.
One paragraph, that's
which is,
right.
which is in the first certificate.
Experts one is shorter.
Right.
Right.
So that paragraph defines the scope of the evidential value of that certificate or the authority of that person.
Correct.
It says that I have maintained the record, I am owning the record, or I manage it, or I operated it.
Correct.
That is not in the expert part. So if one person gives both the certificates, the one will deal with the custody and the authority of that person over that digital record, and the other, as an expert, it will enable the court to focus on the
Second part.
technical details.
Second
that is
part.
hash values and whether it is been tampered or not. So that
No.
will be the difference in between these two capacities.
Sir, with due respect, what ma'am had pointed out is altogether a different thing. What you are saying is right, that though the paragraphs make it clear that the expert's declaration is different from the owner's declaration, but what is probably escaping your notice is that the owner has those additional declarations that I own this gadget, I have taken the printout. But who says that the expert he can't say in the second part that I am also the expert?
No, there is no
I may
bar.
not true.
There is no bar.
Correct.
But the thing, the difference again is, the earlier certificate enables the party to assert that I have produced the evidence.
That's right.
And the second certificate, even if the same person is giving it
Yeah.
in the capacity of expert, he says that the produced evidence is of that particular hash value or maybe all the details.
Right.
So the difference will be the first
Only that paragraph missing.
The first certificate will enable the court to look into the source of the digital record or evidence,
That's
as
right.
well as the authority of the person to have the control, which was in the 65B4, which is in the 65B4 right now, that he is in the lawful possession or control of that digital record. And in case of expert, it will be on the technical side more or less.
Correct.
That
But
is
what
the-
ma'am has said, that what if that owner is himself an expert? So he can sign the second part also.
Certainly, sir. I'm just
Distinguishing. Yeah, that paragraph.
Firstly, the first certificate will enable him as a party to assert something.
Correct. And
in the
second as an
certificate,
expert. As an expert. So now, I'm sure with this discussion, we all are aware that the courts are going to interpret this 1st July onwards in each matter. And the lawyers are going to kind of hammer and tong that no, this is perfect certificate, and the benches will have to undergo that, no, how it is different and all that. So that's increasing the scope of an argument. I wish Parliament would have been, in its wisdom, in better sense, to have clarified these things categorically, that there cannot be, the owner cannot be the expert. Had it been there, it would have saved a lot of time of judicial hours. Yes, ma'am.
Yes, I have one question. That in our family courts, it's very common practice that they give us video call recording or audio call recordings on mobiles. Then in such cases, they give just a 65B affidavit along with the pen drive. And along with that pen drive, they give a transcript. Whose voice is it? Who is talking to whom? Nothing is clear. But they say that this is the respondent talking to me, abusing me like this. And in such cases, who will be the expert, or do we need to ask them to send this to the forensic lab to prove the voice recording?
Now, Your Honor is right. This is the practice which we all follow.
Because here it's a voice recording.
Audio.
Not
Audio. I understood. Now, it's a very important intelligent question which we all encounter. First of all, let me make you all aware, because we all are legal experts and not the technical experts, so few things which I learned out of my experience at the bar, practicing for more than 34 years now. That if ever a pen drive is supplied as the source of audio or even video, normally the courts do not accept it, because pen drive is amenable to amendments, and therefore Your Honor would know that the courts insist in getting a DVD of
Yes,
the.
they also give DVDs, sometimes they give pen drive, and as per Family Court Act, everything is admissible on record.
No,
subject
you
to
can
proving
put
it.
whatever you
Yes.
want to.
And
But-
therefore we have to accept. We don't say
Well,
that we don't-
accepting, I'm not denying. Accepting is a bounden duty of every officer, every authority, every court, whatever you want to produce, produce it. I'm talking of admitting. There is a difference between accepting and admitting.
Yes.
So admissibility of an evidence is different from accepting a document. So whoever produces whatever is accepted, you can't deny that whatever you are moving or giving, I can't accept it. Accepting, like, for example, the courts, you are aware, the courts can reject something, but cannot refuse something. So that's the difference. The courts can't refuse, the court can only reject. So there is a difference between refusing and rejecting, so is there is a difference between accepting and admitting.
Here, how
Now-
this certificate or this affidavit under section 63(4)(c)
Yeah.
is helpful, or how it can be interpreted.
I'll tell you, that's what I'm about to say. That, first of all, most of the courts say that bring DVD, not pen drive, because DVDs can't be tinkered with. Pen drive can be. Now, more often than not, if the other side objects to this, then there is nothing left except the courts to direct it to be forensically exact. Because you can't admit whatever is being produced. The evidentiary value of that electronic gadget or production of that document, though coupled with 65B certificate, has no value. It may be simply if a DVD along with a certificate is produced before the court, at the most it can be given an exhibit number. But it doesn't carry any evidentiary value till it is forensically tested and proved by the litigant that yes, this has happened. Because as I just
And the
said,
other party do not give the voice sample.
Sir, it is like we are taking admitted voice sample and disputed voice sample and sending it to the expert,
Forensic.
which is done in anti-corruption cases.
right,
Simple.
sir, you just escaped what I had right point raised. That she said that the other one can refuse to give voice sample under right of privacy.
Then we can draw adverse.
Adverse, that's the answer. Yeah, I was just about
It's
to.
different
I was
in
just about to
family
tell.
courts, not in family court. This is there in their courts, but not in family court.
Adverse inference can't be done.
Provisions are not strictly
Only two
applicable.
things happens in family court. One, they will go for mutual consent. Or other thing, they will fight out for 10 years.
I just, before I come to you, sir, ma'am, I'll come to you. Before I write a note, I'll just try to kind of inform this audience that I happened to handle one matrimonial dispute before the Supreme Court of India, where I was engaged as a counsel. And to my amusement, this is an obligation upon the court because of the statute. And I knew it. Nobody can refuse it. If the bench is saying that, what if we try to make a settlement? So naturally, it's a statutory mandate and which is bounding even the Supreme Court of India. So they are making that offer. It was not actually an offer, it was a command. But before parting, though agreed, I simply said, sir, my lords would pardon me for encroaching my lord's job. And though that settlement effort would definitely go on, but I'm encroaching my lord's job by giving a decision of that settlement effort. Well, who, the parties who cannot settle in 17 years before various forums, what will change before the Supreme Court? Sometimes it does. Wonderful. So exceptions doesn't become rule, that's the problem. And that's fortunately for me, when I encroached the job of honorable judges of the Supreme Court, I was proven to be right, and the bench complimented me, said, you did it, but it's a mandate. We have to do that. So that's why 17 years of what Your Honor has just said, that there are only two consequences, either you settle amicably or you keep fighting. That's true. Yes, ma'am. You have it.
Yes, I want to answer the query from Madam Savaskar that when pen drive or any voice recording or video recording is given as an evidence along with that 65B certificate,
Being circulated, but the fact remains that our judicial officers do not have the competence or training to check that. Merely dependent upon the app will not be sufficient, because why we send the documents to forensic? Because they are the ones who are certifying it, backed by their expertise in that aspect. Suppose if the judicial officer finds out that this is tempered, can the judicial officer draw inference only on the basis of his or her assumption? So that app is there, but that app is not kind of applicable in the court of law. One has to send, if at the worst it can do what? It can make the judge understand that this document is tampered with. But the judge cannot rely on its own hunch feeling or the app deduction. Once the judge realizes that this is tampered with, the judge is more obliged to send it for forensic. Ultimately, what will have an evidentiary value is the forensic certificate, not the judge's app-oriented hunch. Because whether can the judge certify that on the basis of an app? It can't. So though that app is in circulation, though one judge can realize it, but it can't rely on it. Only thing what this app can do is to make you understand that this document is not genuine. Send it for forensic. Happy? Thank you so much.